at this conference, we are already pro-development. We are already convinced that inclusive and sustainable development is something that we need to fight for. So I was thinking that in this debate, it would be useful to hear a little bit more about the valid arguments against transparency and against access to information. The reason I think it is important when we fight for something that we have knowledge about what we fight for and that we understand the arguments against it. So I want to begin with the question, what do you consider the most relevant argument against transparency, and to what extent are they valid? I wonder, can I begin with Beate on this question?
Thank you, Tina, for that very good question. I think one of the most important arguments against transparency is that it can become a deflection device. We can think that we are solving problems by asking for transparency, by asking for information. But as Linn pointed out as well in her speech, if we then don't understand, if nobody understands the information that is being made transparent, then we may be even in a worse state than we were before we asked for that information. Because policymakers, civil society, various lobbyists for transparency may think that they have solved the problem, while they have just created, arguably, bureaucracy for any public bodies that are involved, paperwork for companies and investors that are involved. And if that information, first of all, isn't verified, so we know that it's actually information and not misleading reporting, and then in addition that there are some users of that information that actually understand it and can use it for something helpful, then we are in a worse state. So I think transparency is not always the first place to start.
So there are some conditions that need to be in place for transparency to deliver development. Mm-hmm.
Yes, we see this a lot in the whole area of business and reporting, where that is the compromise fix. The legislators want to do something about business, they ask them to report. More and more and more reporting requirements on business. Generally, no enforcement of anything except for the financial reporting, and not always that, and no verification. So we facilitate greenwashing and blue washing and any color of washing that you like, but very little actual information.
Very good point. And Linn, do you have, what is your view on this? What are the valid arguments? So I think Beate pointed very correctly on the risk that information is just a kind of facade, and it looks like as if we have a kind of control, but in practice that's not necessarily the case. And Linn, do you have any? Could you explain? Because we don't want. It's not necessarily the case that we want max access to information about everything. And do the corporations have any legitimate reason to keep some of the information you discuss confidential?
Of course, what is often discussed in that respect is, of course, their business secrecy and how they do their investments and so on. And I'm really, yeah, and I totally agree with Beate that very often we are asking about information that is really not necessarily worth too much. But their legitimate reasons should, of course, be their business secrecy and, not secrecy, but their investment strategies. I think that's fine, but what they do not have any reason to not disclose is their structures.
Okay, so we need information about the corporate structures and the ownerships, and it should not, and also the board members and everything. But it should be possible to keep secret their business strategies for competitive commercial reasons. Okay. Let me move to my question number 2. Because you mentioned, Linn, that there are some constraints that we cannot achieve everything by help of law, legal regulations. So, and we know that the various players, they have choices. In many settings, they can release more information than they need to. And given your research, could you point at some players? What players would you say could be bolder in terms of releasing information? And now I'm thinking about your areas of expertise in private law, corporate law, and also state-owned ownership. I can begin with you, Linn, this time.
Yeah. Well, where they can be bolder, I think today it's too much about the reputational values that is in stake, I think, for in matter of transparency. We also touched briefly upon this. And we also saw that in the H&M, where stores in Bangladesh were burned down some years ago. They didn't have to take any responsibility, legally speaking, but they did by reputation. So you can say being bolder in their transparency concerns, if they actually had more transparency about their structure, and not afterwards saying that we want to do this based on reputation because some very clever journalist figured out that there was a link, then I think more of a legislation would be also more efficient.
Okay, so but who in the companies should release information, do you think? Should it come from the management? Should it come from the board? Who has the responsibility to be bolder and proactively release more information?
Well, of course, in the company law context, it's of course the board of directors who hold the responsibility and also the should be well informed about everything that's going on in the company.
Okay.
And when we look at the corporate groups, then of course, like in Norway and very many other places in the world, the corporate group board is not a legal size. It's not you cannot find those words in the law. But if you have this kind of body in the corporate group organization, they of course should also hold a responsibility to know what is going on.
So then you would say that, for example, the Norwegian government, which a whole has significant state ownership in several large corporations, they, regardless of what the law says, it has a clear responsibility to make sure that we as citizens have all the information that we possibly can about the corporate structures in the state-owned companies.
Well, the state-owned companies, they are shareholders and not necessarily board of directors, even though they appoint the board of directors. So, but again,
there is some, yeah.
Yeah, but so as shareholders, as Beate also touched upon, they have very, very limited obligations and duties. So, and this is also, of course, an argument that Beate can, of course, elaborate more about. Upon.
Yes, I want to ask Beate, so what do you think the board of directors should do? How can they proactively release more information? Should they just release all the information about the corporate structure and ownership? That is what you're saying.
Well, I agree with Linn there that there is very little reason, generally speaking, to not release information about corporate structures. And also, as Linn touched on, supply chains and delivery chains, that is also something that should be quite obvious information that should be made available. We also touched upon the question of the state shareholdings in companies, and although, as Linn correctly pointed out, the state as shareholder is not the board, but it is either the general meeting if the state owns all the shares, or like in Statoil or Telenor, where it owns the majority of the shares, it has the control of the general meeting. And what the state should do is, of course, what they say that they want to do. That the companies where the state is a controlling shareholders, these should be the front runners. So that means that they should use the general meeting to ensure that we have a minimum of transparency in these companies. But I would say that that isn't enough, because if the state as a shareholder is of the opinion that something is necessary to do for business, then it shouldn't just enforce that in companies where the state is the shareholder, but enforce that generally through law. There is one important issue that is often mentioned when discussing transparency, and that is especially for the listed companies where the shares are listed on a stock exchange. Then the argument is that information cannot be made available here because there are the interests of the other shareholders to take into account, and also there is securities law and stock exchange law information. And that is often then used through this faulty logic as a reason for not making any information available. We saw that in the Telenor VimpelCom case, for example, that it was said that no, we can't say anything about VimpelCom because there are other shareholders involved and there are stock exchange in other countries involved. But that doesn't say whether information can be made available, but it only says how that information should be made available. So of course, any shareholder or any board needs to take into account the whole complexity of regulation that that company or that group is subject to, but they shouldn't use any part of that regulation as a shield for not making information available.
Mm-hmm. And that happens.
Yes.
So would it be if you have a large owner who wants to operate responsibly, but the board of directors will not release information, would it be illegal for that owner to go against the board and release information that the company wants to keep secret?
Well, that depends on what kind of information you're talking about, or what kind of relationship that shareholder has to the board. As Linn said, it's the board's responsibility. The board is the organ that has the overarching responsibility for the company and for its strategy. And as a matter of company law, if a large shareholder wants to instruct the board to do something, then they can do that through the general meeting, although there are some limitations. But according to Norwegian company law, which is a very hierarchical system, the general meeting is the highest authority in the company and can actually instruct the board to do something. Whether a shareholder can release information on their own, it depends totally on what kind of information that is. It could be something that would go against the company's interest to just release, and the shareholder could be held liable for that kind of reason. It could be information that is protected by business secrecy rules. So we can't just generally say that a shareholder can. But yes, it's possible.
Do you have comments on this?
No, I agree with Beate. It's the board of directors. Well, of course, the general meeting can, of course, fire the board of directors.
Yes, but then you can have large owners who are not majority owners. They cannot control the shareholders, and then they can still. So it would be possibly against the law if they release information about corporate structures that they have. Could be.
Yeah, it could be, but information about corporate structures, about, for example, which subsidiaries and which shareholdings the company has, that is something that, generally speaking, should not be problematic to make available. And also, as you touched upon it, large shareholders that don't have the majority, they also have a responsibility. That is something that often goes under the radar in the Norwegian debate. Because we've had, there is this international trend of discussing shareholder duties and not only shareholder rights. Although we haven't seen that properly integrated into the new EU, or the reform of the EU Shareholder Rights Directive, as I mentioned. It's quite a forceful international debate, which we see not in the hardcore law, but we see it, for example, in the OECD guidelines on multinational enterprises, which Norway, as an OECD country, has supported very strongly, and the Norwegian contact point, national contact point for the OECD guidelines, which is not it's not a court, but it is an arena where one can make a complaint against the company and then have some kind of mediation, and then the contact point can come with a statement. Norway has supported this very strongly, and we have a good national contact point. And then there has been a little bit of less support from the Norwegian government of the OECD national contact point after it actually dealt with 2 cases against the Norwegian pension fund Global, the Norwegian oil fund, which by definition has a very, very small percentage of shares in all of the approximately 9,000 companies where it is invested. And I don't think anyone in the Norwegian government could have envisaged that somebody would say that the oil fund was actually responsible for anything. But it was found. The contact point concluded that it has a responsibility here, and that led to very hectic negotiations in Paris to try to influence this. But the result is that it is clear that also minority investors have a responsibility to influence the companies that they own in a way, not legally in the sense that they can be taken to court for it, but this is another part of this driving force.
Responsibility, yeah. And that is exactly a very important keyword. Who is responsible? Because from an economic perspective, we think that a corporation is one big entity, and we think that that the headquarter optimizes its strategy and tax planning on behalf of the whole corporation, while in law, each entity is a separate entity with its own responsibility. So in my perspective, there is a mismatch between law and economics on this specific area. That is something you agree. Linn, do you have a comment about that?
Yeah, absolutely. And I looked into also several economic theories, and it's the same. Economists, they look at the corporations from inside. They're looking at the money flows and the central steering. But in law, we're looking at it the other way around. We're looking at it from an external context. Where does the control actually end? Which companies are to include in your structure? And this is very often based on the legal requirement to file a consolidated account, which again can have some implications for taxation. So we're looking at it from very different perspectives, and I think that the way forward should really be to integrate these 2 perspectives and fully recognize also in law also these internal processes, because as we have said several times in our research, that the gap between law and practice when we're looking or analyzing the corporate group is huge and it's growing.
Yes. So lawyers and economists need to speak to each other more. And that's something I work for. And we also found now that this is not only about access to information and transparency, but also it's about where we place the responsibility. Who is responsibility? What entity is responsible for sharing what information? And what is the responsibility of the headquarter entity versus the individual separate legal entities? These are crucial issues. And before we leave this debate, I just want to move a little bit into the question of the facilitators and those who contribute to the planning, because sometimes it seems like those are not, they have no responsibility at all, because they just help their clients navigate in a complex financial landscape, while the clients, they just listen to the facilitators' advice. And by facilitators, I'm talking about the lawyers, the various financial advisors, bank employees, and so on, who instruct the companies, the leaders of the companies, about how to set up the corporate structure, how to plan the taxes, and so on. Do you think these advisors should have, what can we do to influence their choices in a sense? Do they have a responsibility? Should they have a larger, clearer legal responsibility? And the question is also, in what situations should they be seen as complicit in these legal or illegal acts? Who wants to begin? Linn?
As of course, these facilitators, they are the lawyers. They have a clear legal responsibility for tax avoidance and money laundering. But of course, tax avoidance is a very relative definition. It's difficult sometimes to actually say when you are over the edge from between tax evasion and tax avoidance. And of course, they enjoy these the privileges of secrecy by not being under an obligation to give information. And what is interesting is that a report from the OECD from 2011 showed that they had now, from before, there were only maybe one facilitator for giving advices for which countries to enter in. If you want to do something or have a business who are engaging in something that you think is environmentally damaging, they will give you advice for which country is the best for you to go about that, or for tax rates or whatever. But now they see that the chains of facilitators is not only a one-to-one relation between a corporate group and one facilitator. It's actually a chain, and all of them can then, of course, hide behind a secrecy privilege. So this makes it really difficult to investigate.
So it's very difficult to place responsibility on the facilitators because there's a chain of facilitators there, and no one can be seen as the one who is responsible. Okay.
But, I can just add one thing, but because you can see that the criminal market actors, they will always be there. There will always be corporate groups or individuals who want to explore the loopholes in the regulations. But in these multinational corporate group structures, it's not the CEO who has full information or full control over which countries to engage in or which kind of tax regulations that you can exploit. It's actually the facilitators. So if you want to do something about it, it's not only to look after or trying to reach the criminal actors who will always be more and more creative, perhaps. It's actually the facilitators who are giving on how to operationalize these differences we have in.
But if there are several facilitators and no one can be held liable, then perhaps it's still the client who is responsible. What is you have a comment? We have to conclude.
Yes, absolutely. It's always the board that, at the end of the day, has the responsibility as a matter of company law. But it's a very interesting point with these facilitators. I mentioned the economic theories. And one of the dominant economic theories about the relationship between business and finance is the narrow mainstream version of agency theory, where the only principles that are recognized are the shareholders, and the board is then regarded as agents for the shareholders. But what we ignore then, amongst many other things, is the fact that we have all these what we could call secret agents, these facilitators that are actually making the decisions. But if a company is caught being involved in corruption, then it is depending on the facts, of course, but as a starting point, the board has a responsibility, and then the question is whether there is who has taken the decision and who has known what. What we see often in debates, public debates about corruption, is that the board, although it has a responsibility as a starting point as a matter of company law, both the board and the CEO tends to distance themselves from what has happened, and it is something that is then limited to the lowest level possible. And that is often a pulverization of responsibility even within one company. That is rather questionable, and I think we will see more cases in the future where top-level people are held responsible, not necessarily because they have signed off on the bribery or whatever the case may be, but because they have not done enough to investigate. The report by that law firm about D&B was an example of not doing that properly, where there was very little question about what was done from the top down, and most of the focus was what has been reported from the bottom up. But this issue, which is important within a company, is then magnified many times in a corporate group. Because as you said, in a corporate group, the parent company can have a lot of control, often has a lot of control, but it is each legal entity, the board of each legal entity, that is responsible. And that leads to a total pulverization of responsibility that we need to deal with.
And what you're saying then is also that the board cannot hide behind bad advice from advisors and legal experts, as we have seen in several of the Norwegian cases, that they have said that, we were told by an American law firm that our practices were actually legal. So that is something we have heard several times, but what you are saying is not a good enough excuse. Okay, thank you very much. It was a very useful debate.